A will. Everybody's heard of a will. Last will and testament. Most people think that's all you need. And maybe it is. But a will only provide for what happens to your estate when you die. We call it, and we'll have another discussion about this another slide, we call it a testamentary instrument. Think about the term last will and testament. That's a term that ties directly to your death. It has no impact, no control, no provisions for while you're alive. When we talk about estate planning, there's 4 different periods in your life that we are usually going to be addressing. And this applies if you're married, there's 4 periods. If you're not married, there's not some 4, there's 3. But anyway, let's say you're married. The first period is when you're both alive and healthy. That's period 1. Period 2 is upon the disability of either or both of you, but you're still alive. Period 3 is when one of you passes away and we have a surviving spouse. And period 4 is going to be when the surviving spouse dies. So keep those 4 in mind. If you're not married at this time, if you're divorced or widowed or something like that, then we don't have the surviving spouse issue because there's just one of you. But that's generally how we're going to address estate planning. When we talk about a will, it only addresses what happens when you die, not what happens when you're disabled. And that's a big factor that we have to address, and that's a big issue that we try to help people think through. So if it's a younger couple who have that couple has minor children, it's also going to appoint guardians for the children. It's going to appoint a personal representative to administer your estate. A will necessarily involves probate. Probate is the legal process with the person in the black robe sitting on the bench making decisions, if necessary, about what happens to your estate, especially if the estate or the probate is contested. And I've done a lot of contested probates. So, nothing here in the will by itself is going to address when you're alive and healthy or when you're disabled. Legal process, it validates the will, makes sure the debts are paid, administers the estate, makes sure the distributions are done. In South Dakota, probate is designed to be fairly easy. It's not designed to be expensive, as in other states. California, East Coast, New York, other states, it can be very complicated, very lengthy, and very, very expensive. And for most folks in South Dakota, a probate process can be fairly easy. I can't guarantee it, but that's the way it's designed. Now, 2 things come up. What if it's not easy? What if there's a contest of some sort, a challenge, family members fighting? Or what if you move? What if you do an estate plan now and you move to another state and it becomes less easy, it becomes more complicated? We take those factors into account. The main purpose for a probate, besides the administration of the estate, is to transfer the title of the assets that you own in your name now and to transfer them to somebody else through the probate process. And this is an illustration of a funnel. We call it the probate funnel. If you own assets now, through a will and through probate, it will get those assets down to your heirs or your beneficiaries after you have the fees and the taxes and the administration. So just think about your assets. Not every asset that you have is going to have to go through probate. But for those that do, it goes through the funnel. It can take some time to complete the probate, depending on how complex the situation is and whether it's contested or not. I can tell you that it's pretty much a given rule that if there's going to be a challenge to an estate, it's going to happen in a probate rather than in a living trust, more times than not. So you're more susceptible to some challenge. Your kids may be great. You may not have any issues with them, or maybe not. I've dealt with all those situations. There is fees depending on the complexity of the case and the value of the assets and all that's involved. It can be a fairly expensive proposition. Although it's not necessarily designed to be that way in South Dakota, it is in other states. It just depends. Probate is very public. Whatever you have now when you die is going to be part of the public records, which means that when your heirs inherit, then whatever they're getting is going to be public records. And there are companies out there and there are predators out there who will research the public records. In some communities, you have companies that will sit in the courthouse and watch every filing and gather that information. And what do they do with it? It's not sealed. they'll contact the heirs, your children, grandchildren, and they'll start hustling them for business, offering them services or products. Sometimes claims that may have been out there against someone who's passed away now are going to be asserted against the heirs because it's all public and there's nothing private about it. They'll pop up and they'll say, you've got to pay this. I mean, there's all kinds of scams and issues and things that come up. Some people really want to respect it. And it's the process of the courts that has control over your decisions and how your will is interpreted and your cost and the time and the privacy. Not you. The court. The probate process all has control over that. You lose control. And as I said, the will is a testamentary instrument. It comes into play when you die and not before. So what about your incapacity? What if you have a will and you become incapacitated? You have a car accident. You start to suffer from dementia. You get a stroke. Any condition. A will simply not address those needs, those issues. Who will make decisions for you if you wake up and you don't recognize your loved ones? You can't speak, you can't make decisions, you can't pay your bills. Who will make those decisions? A will doesn't address that. Now, in that situation, we really have to get into what we call a conservatorship. You saw the picture with the judge in the black robe on the probate, the death probate. We call it a living probate when you get into conservatorship. Someone has to be appointed to make decisions for you. Might be easy, might be complicated. If you're married, it's typically going to be a spouse. If you're not married and you have adult children, someone's going to agree to serve in that capacity, and the other should agree as well. Are the kids always going to agree on what's going to happen to mom or dad? I've been involved in those contested guardianship and conservator cases, and it usually revolves around greed and money and land and things of that nature. I've been involved in very nasty guardianship, conservatorship legal actions, even where there was a power of attorney. And so by design, guardianships and conservatorships can be easy, but that's no guarantee that they will be. And so we really want to try to address, is there a way to get around the issue of the incapacity and having to go to the court process called conservatorship? Some people think a durable power of attorney is all they need. A durable power of attorney is great. We use them in all of our planning. We use them with wills and we use them with living trusts. We have them as a backup plan for our... Also, when we talk about wills, there are people who might inherit who aren't able to inherit, or maybe they shouldn't inherit and have all the control. Minors can't inherit money because they're not of legal age. And sometimes you have people who are children or grandchildren who have special needs. Or sometimes you inherit you pass on to people who will inherit who simply aren't responsible. And there's no control over them getting an inheritance outright, a sizable amount of money. And it may not be there. They may waste it. They may fall victims to creditors and creditors, in-laws and outlaws. A will by itself will provide some protection. It's better than nothing. But does it go far enough? Depending on the family circumstances, we evaluate that. All right. Doing nothing, that's called intestate. When it comes to the estate when you die, you still have to go to probate. Either way, with the will or without a will, you have to go to probate. But with the will, your intentions are spelled out. Without a will, you're intestate, and the law says who gets what. And there's no additional protections. Someone has to be appointed as a personal representative. The process controls what happens. Everything's public. At incapacity, if you have nothing in place, not even a power of attorney, you're absolutely going to have a need for a conservatorship, a court process to have court authority. Joint ownership, a lot of times we have this. Some people think that's all they need. I don't want to say joint ownership is a bad idea because as we put a plan together, it has its proper role. But if one goes forward in a plan and says joint ownership with my spouse is all I need, I would disagree with that. Let's say you're married. Let's use the example of a married couple. Lisa and I, we own our home, joint tenants with right of survivorship. If I die, then that asset goes to her 100% on my debt. It doesn't go through probate. Joint accounts with the bank, joint tenants or joint owners with right of survivorship, it goes to her. It doesn't go through probate. But if that's all you have and nothing else and there's no other planning in place, it can create some situations. First of all, a lot of people think that joint ownership by itself is going to avoid probate altogether. It doesn't avoid it altogether in the marriage situation. It only delays it. Take a look at Tom and Ann. They own their assets together. They have a family. She dies, Tom inherits Ann's share without probate because it's joint ownership. It just goes to him. You have to take a couple steps, notify the banks or file something with the real property records, but at that point in time, Tom inherits. Now what happens when Tom dies? Well, it hasn't avoided probate because if Tom dies, his heirs have to inherit, and they're not joint owners. So it may delay it, but it's not going to avoid it altogether. So that's one issue, and I want to kind of clear up that misnomer out there that it avoids probate. It may not. The other is this. What if after Ann dies, he marries Jen, and then he puts everything in joint ownership with Jen, the new wife, who has kids from a previous relationship, and then Tom dies. This is kind of an extreme situation. It's not too unusual, but let's just use this as the example for our discussion. Well, if bank accounts, cars, the home, if everything goes to Jen because he's married to her, then if there's no planning in place to provide for Ann's children with Tom, it's possible that Jen's kids will receive everything, and Tom's kids with Ann may be disinherited, even if it's unintentional. Unintentional disinheritance happens more times than you think. And it may not be this dubious. She may not be a gold digger. It may have been with just neglect. All right, so here's another one. Give all your assets away. Some folks, I'm going to give it to my kids and they're going to take care of me. Who believes that that's guaranteed? You know? Who really believes that that's going to be guaranteed? I usually sit down with my clients in our first consultation in my conference room and I said, did you bring your crystal ball today? And they, well, no. I said, why not? Well, because we don't have one. We don't know what the future's going to hold. Someone may say, it may work out perfectly fine that someone who has adult children, and especially if they're elderly, they're going to say, I'm going to transfer the assets to my kids, and that's going to be good enough. I can qualify for Medicaid, or they're going to take care of me, or I'm going to give them an advanced inheritance. More times than not, in my experience, that turns into absolute disaster.